Hello and welcome to today's program titled Pioneers and Pathfinders Virtual Roundtable Series, Understanding the Legal and Commercial Challenges of Disinformation and Deepfakes. All participants are in listen-only mode. However, you're encouraged to submit questions throughout the presentation using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and it is required for the CLE credit request form. You can find a link to the request form in the connection details email you recently received. Copies of today's program recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to our first speaker, Steve Poor. Steve, you may begin.
Thank you, and good afternoon, everybody, and thank you for making time to join us on this edition of the Virtual Roundtable series, dealing with issues around generative AI and artificial intelligence and the evolution of technology. As Sophia said, today's topic deals with deepfakes and disinformation in a world that's become increasingly virtual. Let me start by just sort of framing the issue that our panelists are going to talk about. Deepfakes utilize a form of artificial intelligence, machine learning, to create believable, realistic videos, pictures, audio, and/or text of events that never occurred. They fall underneath a broad category of synthetic media. Now, let's be honest, the manipulation of information is as old as mankind. But as technology has evolved, so has the ability to persuasively manipulate information to create alternative and false realities. Now, we all remember Photoshop and the ability to swap faces. It's been around for a while. But as generative AI has swept across the landscape, the sophistication and pervasiveness of this issue has exponentially increased. Now, we probably are mostly familiar with the use of deepfakes in the case of non-consensual intimate images, NCII. A recent Wired study found 50 different bots on the app Telegram with 4 million monthly users, all of which are designed to so-called nudify people, including children. The Atlantic reports on a study that found that 15% of U.S. high schoolers were aware of at least one NCII incident in their school. Although this may get most of the publicity, the challenges of deepfakes have spread to all corners of society, from producing false evidence to spreading disinformation, to corporate social engineering attacks, to fraud, to corporate liability, to list just a few. It has become a pervasive problem. We're joined today by a group of panelists that bring expertise in this area from a number of viewpoints: societal, corporate, judicial, and legal. And let me take a minute and introduce them. Judge Paul Grimm is a distinguished jurist and legal scholar known for his extensive expertise in evidence law, electronic discovery, and complex litigation. He served as a United States District Judge for the District of Maryland, where he established a reputation for thoughtful rulings and contributions to judicial practices, especially around technology's impact on the legal system. Judge Grimm has become a leading voice in adapting judicial standards to modern challenges. He's also recognized for his academic contributions, sharing insights through teaching, speaking, and writing on critical issues in law and technology. He currently serves as the director of the Boltz Judicial Institute at Duke Law School. Also joining us is Catherine Porter. Catherine is an accomplished executive and recognized leader in digital identity and verification. As Chief Business Officer at Prove, which is a leading provider in identity verification and authentication solution, she plays a pivotal role in shaping the company's strategy and advancing its mission to secure and simplify digital transactions. Catherine brings a wealth of experience from her work with technology-driven companies, focusing on innovative approaches to fraud prevention and user authentication. Her expertise in digital trust and consumer experience has positioned her as a key figure in driving Prove's influence in evolving landscape of identity security. And finally, I'm joined by Puya Parto-Navid, one of my partners at Seyfarth, who's a seasoned attorney and thought leader at the firm. He specializes in the intersection of technology and the law and is known for his expertise in data privacy, cybersecurity, and intellectual property. He advises clients on navigating the complex regulatory landscape governing digital transformation. Thanks to all of you for taking the time to join. We're looking forward to the conversation. Catherine, let's start with you. Talk to us a little bit about the issues around deepfakes and trust in a digital environment.
Sure. Thanks so much. I really appreciate being here today. This will be a fun conversation. Digital identity has been an opportunity and a challenge since we've been living our lives online. It's certainly true for digital immigrants like myself who came to the web when I was in college. It's more true for my son, who's elementary school age, and he is completely a digital native, living almost all of his life online. So as our lives have irrevocably become more and more served by being who we are on the web, that means that there is a real need for solutions that can help continually verify you are who you say you are, even if you are, for privacy reasons, using a pseudonym, like I do on some of the social media sites, like my son certainly does in any of the gaming environments where he's allowed to play as an elementary schooler. These are large-scale challenges that exist with our lives also being positively served, bringing the world together online. So digital identity has been a problem that we've been solving, particularly at Prove, for more than 10 years. And I think when we look at the opportunities and challenges that are presented to us, intersection of identity and artificial intelligence, where very quickly, sooner than later, as we have been creating online personas for ourselves through all of our transactions, both personal and payment oriented, we're now going to very quickly, this is not far in the future, this is likely in 2025, have agents who represent us in commerce, who can be stamped out for the Catherine Porters or the pseudonyms that you use on the web and start to interact as a consumer on your behalf. Customer service that historically deals with so much fraud for social media sites, for financial institutions, those customer support centers are becoming entirely AI generated. So helping those agents on the customer support side be able to automatically detect when they're working with a verified user versus a bot or an agent, and being a first line of defense in sophisticated fraud is going to be even more essential as we head very quickly into the AI world that we're going to discuss today. So lots of topics. Prove has been in this space for more than a decade, and happy to engage with everybody today.
Look forward to it, Catherine. Judge, let's turn to you. Sort of share with us your thoughts about deepfakes and some of the societal implications of it, particularly as it relates to the judicial system.
Right. Well, building on what Catherine said, which is exactly right. I mean, we are now in a digital environment. We live that way, and algorithmic software applications, including generative AI, which is where we really worry the most about deepfakes, are ubiquitous, and there's billions of dollars of investment going into developing new forms. Just like Catherine said, you have to be careful because these software tools are like any kind of a tool. They can be used properly and they can be used improperly. And some people tend to look at this type of technology as either dystopian. Some people look at it as utopian. It's probably just topian in the middle someplace, if that's a word. Depends on how you use it. So there's promise, but some of the challenges is that the most effective deepfakes really didn't even exist in our lexicon until 2017, when a person on Reddit called himself deepfake, and what he did was, they were really, by today's standards, pretty crude. He took a porn video and put the facial features of movie stars on that, but it was open source, and so all the all those people who spend time in a dark basement and not outside getting vitamin D all chimed in on how you could improve it. And before you knew it, we got some very realistic looking stuff, and it became generically referred to as deep fakes. That's different from shallow fakes, which are actual fakes, the actual video that's authentic, but it's manipulated in a way that makes it appear is presenting in a way that wasn't done. And now with all this free digital media that you can get for almost no cost at all, cheap fakes, where you go online and you can with a very short period of input from either audio or visual, you can make very realistic audio visual or audio presentations. I was reading on some sites that it's expected that by the end of next year there'll be over 8 million deep fakes floating around on the internet. And they have the ability to impact in a macro and a micro way. The macro way is, we just got through with an election cycle, and earlier in this election cycle during the primaries, there was an example of a deep fake where someone made a fake audio or of what purported to be President Biden, sounded just like him, saying that the polls in New Hampshire were closed, don't bother going in there, everything's all done, don't wait in line. That was fake, and that could impact people. Mercifully, I'm not aware of any significant deep fake associated with the current election, and that's good. There was certainly plenty of concern about that. These kinds of things are macro. They impact people's images and ideas in a way that the legal system, which looks backwards in time, really can't effectively deal with, because you've changed public opinion in ways that are really very significant. And psychological studies show us what I think is all common sense. We've all heard seeing is believing. It's not a big stretch to say that hearing is believing. We think we're very good at when we see something, whether we think it looks like it's real or not, when we hear something. And the ability to make very convincing audios and audio visual videos has the potential for very serious challenges to the truth-finding mission in our judicial system, because our rules of practice and procedure, particularly for trials, are jury-centric. The juries are the ones who decide disputed facts. And imagine, and this is a situation that I have heard domestic judges who are sitting in family court, where frequently they have the parties come, they don't have lawyers, and they'll have one party comes up and say, listen to this voicemail that my ex left on my voicemail. Listen to how he's threatening me. He's going to threaten to kidnap the children and do all these terrible things. And then you turn to the ex-spouse and you say, what do you got to say about that? And the very voice that you just heard making a very convincing threat says, it wasn't me, I didn't do that. And so now how do you cut through that Gordian knot when you have a plausible explanation that this is fake, a plausible explanation that it's authentic? Typically we let the jury hear it, but we know psychological studies have shown, for example, that you're 650 times more likely to believe something that you have seen and heard than if someone has just described it to you. So the traditional ways of having a witness come into court and say, back then, this is what I saw, I heard, I felt, I smelled, I tasted, I touched, as opposed to seeing something that looks like we're right there when it happens, creates the possibility of having a real impact on the ability of juries to decide cases fairly. So we have the possible impact on public views. Why? Because by virtue of us being in the digital media, increasingly large numbers of people get their information that they rely upon in their own lives from social media posts. And I'm ancient enough to where I remember Huntley Brinkley, or even better, Walter Cronkite. When Walter Cronkite said, that's the way it is, you believed it. No matter what he said, there was no doubt about it, and there wasn't the skepticism. Now you have all kinds of sites that may be well-intentioned but misinformed, or they may be purposely trying to disseminate misinformation. And what's the challenge on that is that if the fundamental ability of juries to decide things that they have to hear and see in order to resolve disputed facts is suspect, then you get two things. You get a coin that no one wants. The heads and the tails are bad. The heads is you've got legitimate, authentic audio visual that the opposing party says, it's a fake. Everybody knows deep fakes are out there. You can't believe that. There's where's the computer scientist to prove that? That's not me. And that's the one side. And then that's the liar's dividend. And then on the other side, you've got the possibility that fake evidence will be believed as real when it's not. So these are the other kinds of problems. And the problem with the rules of practice and procedure are that they are technology agnostic. They're neutral because it takes up to 3 to 5 years to get a new rule. By the time you do that, technology has changed. So these are possible implications. We don't currently have rules of evidence that are focused specifically on algorithmic evidence or how to deal with deepfakes. As it turns out, tomorrow, the Evidence Rules Advisory Committee will be meeting, and they will be considering a recommendation that Professor Maura Grossman and I have made regarding an accepted way of authenticating algorithmic evidence, as well as a rule that would deal with how courts can address deepfakes. So perhaps we'll have some idea from them what they think about the need for such rules after tomorrow.
Thanks, Judge. Puya, why don't you fill out for us, give us the legal landscape that we're dealing with here on the issue of deepfakes and identification fraud.
Sure. It's thanks for having me. It's some of the law, it's still a minefield. Some of the law is not settled, but we are moving in the right direction. There's different laws in different states. For example, Tennessee has the Elvis Act, which prohibits the unauthorized creation, distribution of a person's photograph, voice, or likeness. So that's combating deepfakes, but that's under the umbrella of the First Amendment. So it still allows for First Amendment carve-outs for like parodies and fair use. There's a myriad of laws preventing sexual images of sexual content of deepfakes in different states. As in terms of copyright law, it's being attacked on two prongs. One, there's obviously if you create a deepfake that violates that can violate someone's copyright if you have that image in the deepfake. But the way it's being combated on the back end is with the training material. So there's a host of lawsuits about scraping content and the use of content for generating the deepfake. So that is still unsettled, but I think that once that's settled, we'll have a better understanding. The people who are using the content, the owners of the model are arguing that it's fair use. The owners of the content are arguing that it's not fair use. So we'll see where that goes. Under the FTC guidelines, if you use deepfakes for deceptive marketing, then that's a violation of the FTC guidelines. And in trademark law, if you're using a trademark to promote a product via deepfake, that's a violation of trademark law. But I think the most interesting one is the copyright aspect. Also, California passed a law in September that prohibited the use of deepfakes 120 days before elections and 60 days after elections. And a federal judge, handed down a preliminary injunction last month against that. So that, because it violated First Amendment, it didn't pass the strict scrutiny level of requirements. So we'll see where that goes.
Thanks, Puya. So let's start with the societal implications Catherine and Judge Grimm have talked about. I want to get back to the judicial system here in a minute, but what are the steps we can take as businesses, as corporations, or as individual consumers to deal with this issue of deepfakes, this issue of misinformation? How do we figure out what's true and what's not true?
Would you like me to step in from the tech side?
Step in from the tech side.
Great. I'll go first on that. We think about this all the time at Prove and have, like I said, for more than the last decade. When you think about what we have created now with our lives online, we are global users in multiple platforms that have us interacting with each other, interacting with businesses, meeting new people online, and taking those relationships offline. So this is the world that we've created with a really generous web of activity. We've also, in that same time, had the rise of the mobile phone increasingly becoming our key to identity and payments, and being able to pull out the mobile phone out of your wallet and basically replicate what's in your wallet on your behalf. And so Prove took the SIM key, which is a global universal technology. It's used everywhere in the world. And we've created an identity key, a verified identity, by being able to prove that behind your mobile phone number, no matter the name that you're using on the web, that we have verified you. We work with top banks in the United States, top healthcare companies, top insurance companies, top retailers. I bring that up because we've been in a highly regulated environment for more than a decade. So this is a verification tool that is now right on time as we're starting to enter this age of our identity constantly being questioned and needing to be proved daily. So this key, our job is to make it as available and as globally distributed as fast as possible on our major platforms. So the first line of defense on being able to create a circle of trust around when I am interacting on a social platform that I and increasingly all of our children are using, when I am asking for any kind of online connection to then meet somebody offline, whether that's in a car or in a bar or a restaurant, or somebody bringing a service into my home. These are all of the ways that if we verify ourselves with technology like Proves, we are passively verifying. Every time you log in, there's this ongoing heartbeat, a timestamp of, do we still have Catherine Porter verified? That goes a long way to start to help these big platforms understand, here is a segment of verified users. Here in this unverified segment are potential fraudsters, are potential bots for you, big platform, to go back and investigate and do more step up on whether or not these people are real. So the first line of defense here in that largest segment of the funnel is, can we verify that you are who you purport to be in all of your online interactions? And the second, I love what Judge Grimm was bringing out about seeing is believing. It's going to become almost impossible for all of us to counter, even accurately, factually, when our reputations are at stake, because the dissemination of information is at the speed of light. Once it's out there, it's almost impossible to retract. So what we work on as we think about the future of this content creation and these deep fakes being created is, how can we help these software services that are the platforms of information creation start to watermark that content creation with verified identity? It's a first step in this direction. When you're using a software service to manipulate photos that you've taken for sale on the web or dissemination on the web, if there's a way to also verify the identity of the content creator in that moment, that identity, that verified identity, is captured and perpetuated in metadata of that image. When I think about Judge Grimm's challenge in the court of somebody who is misrepresented and needs to, seeing is the belief, But then if you can open up the metadata on what was seen and expose more identity verification, that is a step in the right direction of protecting users and consumers in this new age of information creation. I'll stop there because that's a lot. That's how we think about it today.
Judge, I see you shaking your head. Are you in agreement with that?
Oh yeah, I think Catherine's exactly right. I mean, this is I mean, it's no accident that people who have been in this area for a long time and seen the direction that we've been going, and know that the impulse to do more and more digitally. You know, I was on an airplane today, so I had my ticket digitally. You know, you go to a bank, they have it digitally. You want to get, when I want to get into Duke Law School, I put my cell phone over there and it makes a digital connection to it. So all of these things are being done, and you can't go backwards on that. If we can embed information at the time something is created, that will give you some confidence that it is what it purports to be. Nothing is foolproof, but that doesn't then suggest that you therefore do nothing. It means you do the best that you can. And if you determine that something has been compromised, then you add to it. So we're all familiar, well, maybe not all of us, but many of us are familiar now, when we first learned what metadata was and what digital information was, of a hash value, and taking a file once it's created and having I think it's 32 characters, or it may even be more than that, a unique code that particular digital file has, that if you were to take it and that you were to just hit a keystroke one time within that data, it would produce a whole different hash value. Well, that's a form of authenticating. But what Catherine was talking about is, we're talking about creation authentication. The concept in the analog world of a watermark, the really expensive paper that you hold up and you can see embedded in it a symbol that if you do it, it's not there. Many of you may have gotten a check that says, you know, if you try to do a copy of it, you see void that comes in, or it will have some, to be able to verify this is accurate, it will have these characteristics, these visions. Even the money now has different things, and your driver's licenses will have holograms and things in there. So this is an example of how technology changes to give you that first step. Now, the greater the risk of misidentification, for example, in management of very sophisticated financial software, then you're going to have more than one level. But for the other things, like the audio file, if the voicemail machine that is left on has some way of embedding information that can show that it was on a voicemail machine and who that person is, or some other watermark or embedded feature to it, then that goes a long way of increasing the trust that people have in that. The people who want to gain that will always be trying to gain that, and so it's always a, you know, so it's always a race to try to keep up with the changes. But I think that people who are in this space and realize how important this technology is are spending a tremendous amount of time and making some very big improvements in terms of how this would operate. Then what has to happen is that you have to convince all the different platforms that use it to buy that, so that they're participating in that as well. So I think it's not correct to say that, you know, to throw up our hands and say, well, we need to bury our heads in the sand, ostrich-like. The people who are dealing with this technology are doing wonderful things on that. But you would like to have some sort of, you know, consistency in methods are doing, or programs, best practices. It will soon be a circumstance, I think. Catherine, you can weigh in if you disagree, that if you don't have certain indicia of authentication, then the default's going to be it's not authentic. So that the app of one of these things is going to be just disregarded.
Absolutely. And I think it's important on two fronts. You know, it's the authenticity of the identity verification that you're even using. So we know that there are a number of software platforms that in the age of AI have gone in the direction of biometric proof. The challenge is that the biometric proof itself is really easy to defraud with faked technology underpinning likeness. So going back to the simplicity of using SIM as a key, it's universal, it's global, and we can instantly verify the authenticity of that mobile number attached to a verified user. In Judge Grimm's case of, could we look at a voicemail and have some sort of data attached to the voicemail? It may not be in the voicemail, but it would certainly be in the phone number. You know, we like to say it proved that even a fraudster calls her mother. I mean, there's a number that's associated with Catherine Porter that will, you know, is 20 years my phone number and does not change because it's who I am in the world. And we know that fraudsters and even worse bots are attached to systems, simple systems that are using burner phones and disposable phone numbers. And so that signal is really important for us as a software company to continue to stay in front of, so that anytime a user's identity is attached to that mobile number and, you know, the voice into customer service center or the voice into voicemail purporting to, you know, have somebody at ransom or somebody's died and they need access to the account, et cetera, all of those fraud scams that exist out there. We do have technology today that can start to get after how do we know good user from not from bot and really start to control the fraud there.
Absolutely. Puya, let me direct this question to you. Picking up on something Catherine just said, where's the line between the legitimate use of this technology in terms of creating content for artistic purposes or creative purposes or intellectual purposes versus illegitimate use of it?
So Getty Images has a model where they are using their content to create new images for generative AI, and they share the revenue back with their content creators. So it's a licensed model. They respect the copyrights of the content creator, and they use that for, you know, if you want to make advertisements, if you want to have a picture in your editorial or newspaper, or whatever content you want to create, there's a need for new content, but you have to respect the rights of the owner of the content. So that can be a legitimate use of this technology. Or, you know, you want to create a new song and you want to have a mix of, you know, Elvis and Michael Jackson, and you can create that content, but you have to respect the rights of the content creators and with the permission of the states and license, share the revenue. So those are some legitimate uses of this technology. The illegitimate uses are, you know, creating songs without giving rights back to the content creators, creating images without giving royalties back to the content creators, or political misinformation. You know, we can see where this can go when you abuse the system. You don't want to be. It's kind of like, you know, in the Matrix where the humans were batteries for the AI bots. We don't want to be just content. We don't want to be creating content and it being used without respecting the rights of the content creator. We're not just here to create content for the AI. We're here to, you know, license it. I think a licensing model where there's, and this is it's been going on now, where companies are licensing the content in order to train the models. Because, you know, if you get garbage in, you get garbage out. But if you have good content to train the models on, then it's going to create good output. But it also goes into letting the users know, like if I post pictures on Facebook or social media, I want to know if my content is going to be used for training. Like there needs to be that transparency. If it's buried in the end user license agreement and you don't know about it, then I think that creates problems.
There was a fascinating AI conference in San Francisco last week where the truth is that Bloomberg GPT was trained on a number of sources, including the entire corpus of Enron emails. And so it was called, sort of the ghost in the AI machine, which is this ghost of identity in conversations and in language that is down to the user again. Who were the original sources of this information? And if you can get verification of where the thought and the language and the exchange came from in order to train models that you're using every day for your search results, this is an additional area where knowing exactly where that source of information came from will be critical.
Let me drill that down a little bit. Judge, I want to pick up on a scenario you talked about in some of your first remarks, which is the family court example, where you've got two parties, maybe they're both not represented by lawyers. They're normal people that don't have enormous resources to spend on finding experts to track verifications or opening up metadata. And you've got a judge who's doing the best she can, but doesn't have a lot of resources to identify bad actors. How does that issue get, even putting aside the rules of evidence that be applied, from a resource standpoint, how does the system cope with that issue?
Yeah, that's a great question, and I think that one of the things that obviously, what Puya was saying and what Catherine was saying is that the more successful we are with coming up with standard and sufficiently verifiable authentication, then the less worried we are about needing an expert for every kind of dispute that gets into court. We all worry about that. And we also worry about the imbalance of having a well-resourced defendant with their computer expert and a person who does not have that resource, frozen out of being able to have be on a level playing field. But I think what you do is the first step is judicial awareness, and we do a lot of teaching. And there is an insatiable appetite on the part of judges, state and federal, to have a better feeling for that. This is international, and the fact that so many of them want information upon that, I think, is a great thing. The judiciary knows that this is out there. They want to know what are some steps that we can deal with. Well, if it takes 3 to 5 years to get a new rule, what do we do in the meantime? Say no cases? We're going to put this on hold? No, of course we can't. So you come up with existing rules to be able to use that. And some of the articles that I have written focus on that. And some of those would be something just as simple as Maryland, the state of Maryland, came up with a law in the 1990s, before we were even dealing with this kind of algorithmic evidence, that dealt with computer-generated evidence. And it placed an affirmative duty on a party that was intending to introduce computer-generated evidence. And it defined it so that, your digital camera or just, an ordinary business record would be excluded, so that it didn't freeze the whole system up. You had to give advance notice of the intent to introduce it. And then the other party had a certain opportunity to challenge it and get discovery about it. And then the court, and they had to give notice of an intent to challenge by a certain deadline, as well as a deadline for challenging it. And then the court would be able to have a hearing to be able to decide it. Now, what does the court do? Well, when the court gets in, you use the existing rules to try to deal with how you take a look at it. The proponent has to convince you, more likely than not. That's 51%. That's a low barrier. So if any of you who have heard me talk here were to hear an audio of my voice, you could say, well, here's my opinion that that's Paul Grimm, because I heard him in a webinar and he talked ceaselessly and and annoyingly for 30 minutes. And so we know what he sounds like. That's his voice. That's enough for that first level. Then what judges have to do is they have to look for the corroboration, and they have to ask themselves, is this the only evidence and the most critical evidence to support the outcome that the parties are arguing over? If it's not, then the more corroboration there is, the less likelihood for prejudice. But where it becomes key evidence, or the risk of getting it wrong is unacceptable, someone goes to jail for 10 years or loses their property or their reputation is devastated, they lose their job, then you have a higher level of certainty that you have to have. And you use existing rules that allow judges to evaluate the prejudice that may be attached to it with the probative value. Now, there are certain types of courts, small claims courts, courts involving domestic relations where you have a lot of self-represented folks, where the best of intentions are going to be difficult because you've got a judge sitting there who's got 100 cases on their docket. I don't care how hard you work, and these judges work very, very hard. Then you're just going to have to, there's a certain amount of intuition that you're going to have to do, but asking the right kind of questions. What technology people can do is they can come up with sort of standard questions that you might want to do. If it's a picture, it appears to be a picture, ask these kinds of questions, Judge. So we can partner with Puya and Catherine and get cues from them, identify the kinds of things. If it's audio only, what are the kinds of things that we should be asking? When I do judicial training, they ask for things like this. So I see this partnership with technology and the courts developing the kind of strategies that come up. And I know for a fact that if you got like a court, the family court from Delaware, if they came to someone like Puya, and they came to you, Catherine, and said, we're having these kinds of problems, help us get information from various types of technologies as to the kinds of questions that we should ask to enhance the likelihood that we're getting it right. I think people in the tech sector would jump all over that to try to make sure that they had some of those cues. Not perfect, but better. As you get into the larger cases where there's more pleadings, more filings, more resources, then disclosure requirements, the development of standard protocols that can be a basis for relying upon them. Again, technology partners with law. So I see this developing over time. My concern is that, and this is the purpose of the writings that I have done with Dr. Grossman and others, is that we don't want that first decision by the judges to get it wrong. Because once that happens, you get a series of decisions going the wrong way, and trying to back that up is very challenging to do. But so we'll always be somewhat behind the development of technology. But if we work together with these, what I call technology and judicial partnerships, and I have every confidence that the people who know the technology would be delighted to do that, then we can come up with some programs that we can get out there and make a big difference. So that's my hope.
It's my hope too. I mean, I think, as technologists, you do sometimes fear the bureaucracy that comes with working with, federal and congressional and large bodies of regulatory activity. That said, in this new future where AI intersects with consumer every single day, it's going to be necessary and needed for the safety of users. So to the extent that technologists can get in early with better, not perfect solutions and be learning, it's our job, because we have the computers and the algorithms to scale faster than even human thought and human execution. It really helps keep our consumers safe.
Let me follow up on that. Judge, you mentioned this has the attention of the judiciary on a global basis. And Catherine, you've mentioned the use of the international standard SIM. What it broaden and the issues around regulators and various bodies, judicial bodies, it's a complicated set of interrelationships. How does that work on a global basis, either through the judiciary or through regulators or through global companies?
Who are you, Stephen? Who do you want to take the first shot?
Either one of you.
I can go first.
Raise your hand. She raised her hand.
I have less information than Judge Grimwell, so I'll go first, and he can be thinking. I experienced a little bit of this, not in my current role, but when I was at Meta and was actively involved in the creation of the Libra ecosystem that was meant to be digital stablecoin, digital currency for the globe. And I think it's true based on the little bit that I've seen. I've been approved less than a year, but when you have leading edge innovation that is in service of consumers, being proactive about educating regulators, starting in the US, obviously, because our work is headquartered in the US, our relationships are going to be primarily US legacy. But that's important because I think the rest of the world cares about US regulation around the internet and around consumer safety. And so while there are discrepancies as you're building your regulatory relationships, which we have in hand at Prove and care deeply about, certainly true of an organization like Meta, where you are building out proactive relationship in order to keep people apprised, working in a regulated environment like we have at Prove with banks has meant that it's been essential in working hand in hand, having these proactive relationships. When you do that, you're better prepared as a global company for the slight differentiation, or sometimes a large differentiation in places like Europe and the UK, and then certainly into Southeast Asia. So all I'm saying is when you are excited and optimistic about leading edge technology, you also need to be, that's serving consumers. You need to be responsible for building out the right relationships early with regulatory body and keeping them educated. The education cycle takes time and it's important, it's responsible. So having those relationships in the US first, I think helps as you start to scale your technology globally. Judge Grimm, I don't know what else you would have to say.
All I would say is that these partnerships are essential. In the Europeans are ahead of the game on us in some of the developing some of the regulations, and have an appetite for regulations. In the United States, the approach that we've taken has not been top down from government entities directing that down, but I think a refreshing degree of humility about the absence of knowledge, and to try to get leading players, legitimate leading players within these technologies to the table to say, all right, what can we agree upon? And so we get input from those who are the ones who will ultimately be regulated as to what consensuses are. Once you get a whole industry saying, when you do these 5 things, then you're doing enough, then that's a good indication of something that you can then come back and say, all right, we're going to put this in there. Regulations should be designed to have 2 types of attributes. They should give carrots and they should give sticks. So sticks for people who are, when you do have industry standards that have been accepted and tested within that industry, and people do not comply with it, then that's a time when you want to look at consequences for doing that. On the other hand, when somebody does follow those, even if it produces an outcome that's problematic and gets you into court, then the carrot should be there. There should be some safe harbor or some recognition that the technology can never be made perfect and will always be subject to change. The challenge with that is it takes time, and there's not necessarily uniformity. So I was part of an ABA group that was invited to Capitol Hill earlier this year, and we went there, and there were staffers from the House and the Senate, all of whom were looking at AI regulation from within the lens of whatever their committee was and whatever their regulatory interest was. And I mean, you don't want to have 15 or 16 different things coming out with that. In addition, actually, Catherine, you might have a better idea than I. I think that as of this summer, there were like 600 draft bills in state legislatures that were making requirements or prohibitions. Priya, you're nodding. It may be more than that now. And so you want to
I don't actually know, but I can believe it.
Yeah. And so you don't, I mean, you don't want that. You don't want, because that's paralysis, and no one can sort of kind of deal with that. But what happens is that if there's this regulated and consumer collaborative, the working together, you can begin to make a lot of progress in ways that you don't have to have the perfect be the enemy of the good. And I am actually quite pleased that we have had that regulatory humility in the United States. You get things like NIST, the National Institute of Standards and Technology, in the Department of Commerce. Instead of coming up and shaking the finger, reaching out and saying, all right, come up with this, look at this, give us best practices, and then putting things out there like explainable AI and certain benchmarks that you want to try to achieve. It's challenging because the technology changes so doggone fast. And we've always had technology changing before the law and the regulators can get there. This just means you have to get the best and the brightest in all of these sectors working together in an area with an atmosphere of trying to come up with something that will improve where we are, recognizing perfection is not possible, and that it's a developmental process that may require that as you go along, you alter or amend what you're doing.
Just to confirm, there's actually an interesting website called multistate.ai, and it tracks AI laws. So it's this year they tracked 692 bills in 45 states, and 111 of them have been enacted into law. So, but nothing on the federal level. So it's yet.
Puya, what is the legal obligation of? Catherine talked a little bit about social platforms hosting this content and the need for verification. What are the legal obligations for a platform who's hosting, including social media, hosting this information to deal with deep fakes?
Well, currently under Section 230 of the Communications Decency Act, there's safe harbor. So unless they're creating the content, then there's safe harbor if they're just posting the content created by others. So that is a topic of discussion of what, I think both sides of the political parties have talked about why trying to carve back Section 230. But as of now, they have limited liability because of these safe harbor protections. So they can host the deepfakes as long as somebody else posted it on the site. I think this might come back to what Catherine and Judge Grimm said. If there's a way to verify it, if maybe there's, you can have a cloud-based hash or a watermark or something that says, okay, now that we know that this is a deep fake or this is generative AI, and you need to verify that it's, legal and fits the parameters that we set. And if then you host it, then it's on you. But I don't think as of now there's a way the safe harbor protects them. So there's multiple levels to this in terms of liability.
I also think, we've brought up this theme already several times where better in this environment being better than perfect. I hear from large consumer facing platforms, both on the internet side and on the commerce side, where the government, not just in the US, but certainly in Europe, are asking them to get granularity around age of user. And so age of user, really that minor versus adult. In the minor space, do you know a 10-year-old from a 12-year-old, where that's the perfect information, but the most important information for these platforms right now, even before you get to disseminated content that is put in front of children and minors, is being able to understand when somebody registers as a user of the platform, that person's representing to be 15, but is that person really 54? And that binary nature of adult or not has a lot of value in today's web safety, consumer safety, where technology exists for that today. And that is a stepping stone to getting to much more granular precaution and regulation around when somebody can be served information at all. So I only bring it up because, I think in the 697 bills, of which 116 or whatever have been passed, and yet there's no federal even guideline yet. Can we start with the basics and help synthesize what we're learning at the state level, local level, up to federal guideline, so we can just start to get to technology that serves this minor or not, bot or not, and use that as a massive step forward into what will ultimately become more precision on who a user is when she's online.
And presumptively, preemption theory under the Constitution, if it's a federal statute that learns from all these other things and comes, it would probably preempt other state regulations and law that are inconsistent with that.
Hey, Catherine, let me pick up on the point you're making because it dovetails nicely into a question we got in advance. And I'll paraphrase it a little bit, which is sort of a two-part question on what can individuals do to detect and discourage misinformation in a virtual world? And how do we handle our children? How do we educate them? How do we train them to identify the 54-year-old as opposed to the 12-year-old?
Yeah. So repeat the first question again. I have the second one. The first question was,
what do we do as individuals? As an individual, what are the guidelines you have for detecting and discouraging misinformation?
Yeah. I mean, I think the first, I will definitely say this, operating from Prove and having come from Meta, is you as an online user have a responsibility, certainly as an adult online user, has a responsibility to understand and report back to these platforms when you're interacting with content that you know is fake, so that you can help those platforms become more sophisticated about tracking it and doing something about it with their own technology. I have solved it imperfectly by also creating pseudonyms for myself in areas of the web that I want to be more transparent, to try and create my own sense of privacy. I think that because I now work in verified identity, I am increasingly looking for almost that Intel Inside branding of, is it powered by Prove or something else that gives me a sense of verification. Some of the customers that we've worked with recently in digital marketplaces are assertively pursuing a verified check mark around their users for the safety of their own two-sided marketplace. Again, back to my example of when you meet online and then you meet offline in any setting. Do you have a sense of that community being verified so that you know that these are real people you're interacting with? It's an opportunity for us to both demand more of that verification for ourselves so that we are creating a circle of trust online. For children, I again go back to the funnel of, where does the problem start? The problem starts, I believe, on our platforms. So as a technologist in this space, it's really important for me to market, sell, and partner with these platforms so that we can get their sophisticated understanding better advanced on when is a child present in the environment and what kinds of content are we sharing with that child. I see it as a technology problem to solve first. For online consumers, for moms with kids, my son and I have the standard that's going around right now around a password that is, if anybody ever contacted him with my faked voice, or if anybody ever contacted me with his faked voice, we have a specific password that needs to be said in order for that information to be validated. So the validation right now exists outside of safe platforms that have been verified. The validation exists in families. The other measure that I'm taking is my son won't have a mobile phone until he's 14.
Okay.
Oh, we've run out of time, folks. Let me first, before I thank the panelists, let me read the CLE code, which is SS2315. And I want to thank the panelists for a great conversation. I know Paul's got to run to teach a class at Duke. Catherine and Puya, thank you very much for your comments and your thoughts. It was a fascinating conversation. Thank you very much.
Thank you.
Thank you very
Have a great
much.
day. Take care. Bye-bye.